Welcome to this explainer. If you're stepping into the Ontario real estate market, you already know that closing costs can completely sneak up on you. Today, we're unpacking exactly how you can navigate these strict property rules without getting blindsided by a massive tax bill. We're diving deep into insights from Mandeep Tour Explains, looking closely at land transfer tax exemptions and the legal frameworks you can actually use to your advantage. So let's get right to the burning question literally every homebuyer asks their realtor as closing day looms closer. When you look at the sheer cost of buying property, it's totally natural to wonder, hey, can I legally avoid or at least reduce this tax? It's a huge concern. And as Mandeep Tour explains, the short answer is yes, absolutely. But you've got to do it exactly by the book. We aren't talking about finding some sketchy loophole, it's all about following strict legal exemptions. Here is our roadmap for today based on Mandeep Tour's insights. We're going to hit the land transfer tax burden, legal exemptions versus evasion, first-time homebuyer rebates, spousal and divorce transfers, family gifts and trusts, and finally, inheritances and corporate rules. Let's get right into it. Section 1, the land transfer tax burden and how much it actually impacts you. Tens of thousands of dollars. Yeah, you heard that right. That is the harsh financial reality for so many buyers. The land transfer tax, or LTT, is calculated on a sliding scale based on your property's purchase price. And if you're buying inside the city limits of Toronto, wow, that burden is effectively doubled because of the municipal land transfer tax. As Mandeep Tour points out, this easily becomes your single largest closing cost, tacking a massive sum onto your final bill. Moving on to Section 2. Legal exemptions versus evasion. We need to know exactly where Mandeep Tour draws the line here. There is a very strict line between being smart with your financial planning and, well, breaking the law. Illegal tax evasion, like setting up shady side deals or fake price adjustments, is a crime. If you try to dodge the tax that way, you are asking for serious trouble. But Mandeep notes that legal tax avoidance is entirely different. It relies on strictly following the exemptions written directly into the Land Transfer Tax Act. You just have to make sure your transaction is structured perfectly. All right, Section 3, first-time homebuyer rebates and the rules you cannot ignore. To actually get your hands on this provincial and municipal rebate, the rules are incredibly strict. First, you have to be a Canadian citizen or a permanent resident. Next, you must occupy the home as your principal residence within 9 months of closing. And here's the kicker. As Mandeep Tour emphasizes, global ownership history completely disqualifies you. That means neither you nor your spouse could have ever owned a home anywhere else in the entire world. No exceptions. Section 4. Spousal and divorce transfers. Let's see how Mandeep Tour's expertise guides us through marriage and separation. If you are simply transferring an interest in a property over to a spouse, there's some really good news. The transaction is typically exempt from the land transfer tax, as long as absolutely no consideration changes hands, meaning zero money or value is exchanged. And according to Tour's analysis, even if there's an existing mortgage registered against the property, it won't necessarily derail this benefit. But the rules tighten up significantly if a marriage is ending. Tukapur warns that if property is changing hands because of a divorce or separation, the new sole owner is exempt from the tax, but only if they have the proper documentation. You absolutely must have a formal written separation agreement or a court order. A verbal agreement or an informal handshake, yeah, that simply won't cut it here. Down to Section 5. Family gifts and trusts. Generational planning done right. Let's say you want to gift a property to your child for, quote-unquote, love and affection with nil consideration. As detailed by Mandeep Tour, there's a critical distinction to make. The property must be completely free of encumbrances. Unlike the spousal transfer we just looked at, if there's a mortgage on a property being gifted to a child, simply assuming that existing mortgage counts as consideration. And bam, you are suddenly on the hook for land transfer tax based on that mortgage amount. To be exempt, it must be entirely mortgage-free. Which brings us to an incredibly common everyday scenario. A parent gets added to the title of a property for the sole purpose of helping their kids secure financing. The parent isn't paying for the house, they have zero plans to live there, they're just providing the financial backing the bank demands. Mandeep points out that doing this creates a very specific legal relationship. In this setup, the parent is essentially acting as a trustee, holding legal title for the benefit of the child, who is the true beneficial owner. But here is the catch. You can't just claim this after the fact. Tour explains you must have formal trust documentation drawn up at the exact time of purchase to confirm this relationship legally. because getting that trust set up correctly from day one is a massive game changer. As Mandeep Kaur explains, when the parent leader seeks to be removed from title because the child can now qualify on their own, LTD can be avoided so long as no consideration is exchanged. By having that trust documentation exist from the very beginning, taking the parent off the title later becomes a completely tax-free process. Foresight pays off.
Our final stop, Section 6, Inheritances and Corporate Rules. When we compare these varied scenarios, Mandeep Kaur really breaks it down expertly. For inheritances that are transferred through a will or the laws of intestacy, the property is entirely exempt from LTT, and that holds true even if a mortgage exists on the inherited property. However, once you move into family farms and corporate reorganizations, things get intense. Highly complex, very specific conditions must be strictly met.
If you are shifting land from an individual over to a family business corporation, you have to hit every single item on this checklist. The individual must have been engaged in an active business on the land, the shareholders must be exclusively family members, and the corporation must continue that active business. Mandeep cautions that if you miss even one of these criteria, the exemption is completely nullified. Because terms like active business carry such specific, intense legal definitions under the Act, this is absolutely not a DIY project. For this reason, TOR insists that consulting an experienced real estate lawyer is non-negotiable to figure out if you actually qualify for these advanced exemptions. Getting this wrong is not just an oops, my bad moment. A failed plan to avoid LTT that crosses the line and violates the Act won't just cost you the original tax. As Mandeep Kaur highlights, it will bring down severe penalties, mounting interest and really steep fines on the buyer. You want to save money, not invite an audit and massive financial stress.
So, as we wrap up, I want you to apply this to your own real estate plans. Are your strategies genuinely protected by these legal exemptions, or are you accidentally risking illegal evasion? Real estate is expensive enough without paying taxes you legally don't owe, or facing audits because a transfer wasn't structured right. Thanks for joining me on this deep dive into Mandeep Kaur's insights. Make sure your next move is a smart, fully compliant one.